Many states do not. Like I assume that California does not, because California, if there's one thing California loves, it's plaintiffs and plaintiff lawyers. And if there's one thing California hates, it's anything related to guns. And so I would imagine that California would never have an immunity law that would extend to firearms instructor.
We are the Armed Attorneys. Today we are answering your questions. These are questions that you leave in our comment section. It helps a lot if you say question and then type out what you want us to talk about, because today we're talking about the boundaries of your castle. We're going to be talking about, hey, what happens if you defend yourself in what might be a prohibited place? And if somebody gets shot in the woods and nobody hears it, was anybody really shot? And should you call the cops about it? But before we begin, show your support for the Second Amendment by hitting that like button. And Edwin Walker, thank you for joining us.
Oh, sure.
He's going to be filling in with Emily for a couple of weeks. Emily is out on maternity leave. We got some well wishes for Emily in the comments, and we'll keep you posted. Make sure everything goes smooth.
Sure. And the first question we have is, in fact, from one of those folks who does a shout out for Emily, Connor Navarrete, 7783. And he states, praying for you and your family, Emily. As Emily's proxy, I graciously accept this well wish, and Emily says thank you. I say thank you to her, to you on her behalf. And his question is, what happens if you carry in and act in self-defense on a 30-06 or 30-07 property? Now, I know that there are probably a lot of folks who are not from Texas, so they don't understand this nomenclature.
Yeah, well, we can make this general. What we're talking about is really if you're, let's say, defending yourself in what is otherwise a prohibited place, or maybe you've been provided effective trespass notice and you're forced to defend yourself. How does that impact your self-defense rights? So that could probably go for a lot of different states. Obviously, your mileage may vary based on your state's law. Now, the question ultimately is, do I lose my right to self-defense because I'm in one of these locations? And the answer is, God, no. Obviously not. You get to defend yourself. However, could it affect your self-defense rights at trial? And the answer to that is maybe, yes. And we see that with the law here in Texas. We have different levels of self-defense. One is just our, kind of burden is on the self-defender to persuade a jury that what they did was reasonable, immediately necessary, and in response to an unlawful threat. Well, we have a second layer of self-defense, especially in our Castle Doctrine locations, in response to some very serious and violent crimes, that the law presumes that you were reasonable, immediately necessary, and you were responding to an unlawful threat. But you might lose that legal presumption of reasonableness if you're not carrying a location where you're legally allowed to be. And I imagine that's the law in quite a few states.
Right. And so you would lose certain presumptions, but you would not lose the ultimate question, which would be, was your use of force or deadly force in the situation immediately necessary to protect yourself from an unlawful threat or use of force or deadly force? Now, one of the kind of interesting twists would be, what if you had an overly aggressive prosecutor and said, I can't make this self-defense case against you, but I hate you so much that I'm going to prosecute you for going into this prohibited place.
I could act
with your gun.
I could see that happening.
Oh yeah, no, we got some.
And then you can't
jerks.
claim self-defense against. I mean, you could claim maybe necessity. It's all going to depend on the facts.
Well, that was what I was leading into, is that you wouldn't have a self-defense argument. Your argument would be necessity.
Yeah.
Unfortunately, most states do have the defense of necessity. So the defense of necessity would say that if you are intending to prevent a greater harm than the harm that is designed to be protected by the law, then you are justified in your actions. And so in the instance where you see a gunman rushing into a school and you're like, oh my God, they're going to kill school children, I better rush into that school myself with my own gun. And the state says, no, you shouldn't have taken your gun in. You say, look, preventing the killing of children is the prevention of a greater harm than me simply taking my gun into a school.
YouTube is going to love all those combinations of words that you just used. But, all right.
And they would find you not guilty.
Different scenario, okay? There is no crisis in the school, and the person unlawfully carries into that school. Crisis emerges. Do they get that same necessity? Because they've already broken the law.
If they're prosecuted for trespassing?
Yeah, or for carrying the prohibited place. They commit the offense of trespassing or carrying in a prohibited place before the crisis arises. And the crisis just happens to be incidental to it.
Well, you would have to articulate facts.
Yeah.
That showed that you had a firm belief that there was a crisis that was going to occur.
Sure, I agree with you. All right, this one is to you. This is oh so cheesy question. Is my gated backyard considered my castle? I live in Texas and I've heard of people getting attacked on their driveway. Is that considered my curtilage? Emily, I pray for you and your baby as well. God bless you both. Thank you. We're passing all these well wishes along to Emily. So, castle extended to backyard.
No.
Yeah, it's a real short answer. No. So, castle in Texas is going to be, building portion of a building. It's going to be your habitation under the same roof line. Outside of that, no real extra defense rights.
Yeah, and your curtilage is more like your moat around the castle.
Mm-hmm.
So it does not extend very far. It does have to be, adjacent to the property. Your gated backyard wouldn't happen. Now, it's kind of interesting that he throws in the attack in the driveway.
Yeah.
Because, if you're attacked in your driveway, then you have many other crimes that have been committed against you. Obviously, aggravated assault, maybe attempted murder, maybe why did he attack you in your driveway? Maybe he was stealing something. That would be an aggravated robbery. And so just because, and, obviously speaking here as Texas lawyers, you would not get the presumption for protecting your castle. You would get the presumption of protecting yourself against one of these egregious deadly force felonies.
Yeah. All right. We're going to go into this one. I'm going to give this one to you also because I'm interested in your opinion. So this is from
That'll be a first.
Robert Gantry 2118. Here's a question. If a gun is fired at an intruder in a cabin in the middle of the forest and nobody hears it, did it really make a noise, especially if the cops aren't called?
Is this the old
Tree falling
no, this is the old I don't know, I got a gun, I got a shovel, who's gonna know?
Yeah, or we call 811 in this house. You call before you dig so you don't hit a gas line.
Okay.
That's the question.
There are no gas lines in the woods.
Sure, okay. I'm with you.
So, this is kind of interesting. Well, obviously, if you inflicted a harm on another person, you are supposed to, call for aid. But, if you're in a cabin in the woods, I mean, that is a habitation.
Yeah.
So if you are, if it's a structure that somebody theoretically could spend the night in, it's a habitation. And so if somebody's breaking into your habitation, even if it's a temporary habitation, you still get the benefit of the Castle Doctrine. So, why wouldn't you call? But as far as like just leaving a dead body and some hunter or hiker comes upon it, and now you wind up on a dateline, and that could be more problematic.
Well, I would just play it out. If it's ever going to come to the attention of law enforcement, when somebody goes missing, somebody gets killed, I'd say it's exceedingly rare that it doesn't come to the attention of law enforcement. For most self-defense cases, you want to be the person making the initial report to law enforcement. Very difficult to say, yes, it was self-defense, but also I did dig a hole out in the middle of the woods 6 feet deep and buried him and never called anybody. That doesn't go over very well.
This kind of goes along the same line about, is it legal to kill hobos? Like, would they even be missed?
I don't know that that's a common saying in my household.
You should broaden your horizons.
Sure.
Next question. All right, from Dookie7. Hope I'm pronouncing that right. Dookie7, question. Love the show. His question is, and we thank you for that. We always appreciate people who love the show. His question is, if I become a firearms instructor and some nut who attended my class commits a crime, how do I avoid getting dragged into their case or sued? Thank you, thank you, thank you.
All right. The short answer is, well, you can't stop somebody from suing you. This is America. All these other states, we have an open court system, and anybody can sue anybody for virtually anything. That being said, does that mean they're going to recover? Well, maybe not if your state has some legal protections for instructors.
Yeah, and legal protections, most states have written these into their civil codes. Legal instructions, legal protections, obviously vary from state to state. Usually it's the product of some special interest lobbying the legislature and say, hey, we need a special protection that, protects us from lawsuits. Some states have them, like Texas has one that will protect instructors from lawsuits involving whenever their instructees commit illegal acts. Many states do not. Like I assume that California does not, because California, if there's one thing California loves, it's plaintiffs and plaintiff lawyers. And if there's one thing California hates, it's anything related to guns. And so I would imagine that California would never have an immunity law that would extend to firearms instructors.
Yeah, we recently had a case that we defended where, really the actor or the folks involved was, a patron, security guard. Well, they went a step further. Obviously, they sued the security guard company. They went a step further and sued the training academy that trained the security guards. So, we were involved in that. We got that case, or our client, the training academy, thrown out very quickly, because obviously you have to have some kind of logical connection between the damages and, what did you do as it relates to that. There's no logical connection between these instructors, especially in most courts. I'll say, a criminal doing criminal things, they're going to say that's a hard break in responsibility when it comes to like training or supervision, even for employers. So I would say won't prevent you from getting sued, but will they recover at the end of the day? Probably not.
Yeah, and for those of you, I know we rarely discuss civil law on this channel, or at least not to the degree that the criminal law is discussed. But for any of you who are interested in doing a deep dive into interesting tort law, look up the concept of proximate cause and Miss Paul's graph and the Long Island Railroad.
All right, next question. This is for you, Edwin Benjamin Long at 2837. Here's the question. If the new program goes through and your rights are restored, but you're still a felon according to law, on the 4473, where it asks, have you been convicted of a felony offense? What do you answer? I got a pardon, so I can legally hit no. I have not, because it has not been set aside. But if you're still a felon, how does that work? After all, as soon as you hit yes, you have a felony conviction, the digital 4473 will kick it out of their system.
Well, and the 4473 is not the clearest form or the most straightforward form that we have, which is really annoying because it affects such a fundamental right as the right to purchase and possess firearms. But that's why it has like 3 pages of instructions trying to help people and assist them in what they could answer, what they should answer to these disqualification questions, in which, it does say on the instruction form of the 4473, exception, pardoned or expunged, a person subject to any of these exceptions or who has been relieved from the disabilities under 18 U.S.C. 925C, which would be the prohibition against somebody carrying who is a felon, should answer no to the applicable question. And so anytime you are filling out a 4473 and you come across something that you maybe don't understand or is confusing to you, immediately check the instructions, and there usually is an answer that will attempt to clarify that for you.
But these are your questions. If you have more of them, leave them in the comment section. That's where we go to find your questions for future episodes. But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video. And until next time, we're the Armed Attorneys.